If it may please the court, my lord, I have overnight prepared short heads of argument in response to an application by the state to lead the following evidence in respect of Mr. Sibia, 2 additional photos, in respect of Mr. Ntanzi, 16 additional photos, and in respect of Mr. Mngube, additional 3 photos, my lord. And in our heads of argument, my lord, at introduction, we're saying that the state has made a substantive application in their quest to have Warrant Officer Ndlovu, who is responsible for the downloading and analysis of the photos that were contained in the memory card belonging to a phone that is attributed to Mr. Ntanzi, and Warrant Officer Mabasa, who dealt with the analysis and download of the photos belonging to to Mr. Mngube. In respect of Mr. Sibia, we are not told who the downloader of those photographs are and the source of those photographs, my lord. And my lord, in the heads of argument of the state, at paragraph 1.4 thereof, it is stated that the state would like to re-examine Brigadier Gininda on these additional photos of accused number 2 and 3. And at paragraph 1.5 of the heads of argument, it is submitted that, and I quote, "The sole purpose for such a re-examination is to put a full and fair picture before the court to enable the court to adjudicate on the issues that are in dispute, namely the identity of the perpetrators who invaded the Khumalo's home on the 26 October 2014 and killed the deceased. It is therefore submitted that the evidence is relevant." That is the heads of argument of the state, my lord. Now, our submissions in respect of, in particular, Mr. Ntanzi, is that my instructions are to object to the recalling of Warrant Officer Ndlovu and denying the state to adduce these additional photos, especially in the context for which the state seeks to introduce them, i.e. to cross-examine, to re-examine Colonel Gininda on the description and the identification. And particularly, my lord, let me go to this. At paragraph 2.2, in fact, before 2.2, my lord, there's a passage that is very, very germane. Yes, at page 5 of the head of argument, the state went to length to quote a passage where I had an interaction with Brigadier Gininda. And in particular, I remember vividly what the interaction was all about, my lord. I was put to Brigadier Gininda in respect of what the witnesses in the house, some of the witnesses in the house described the second intruder. And my submission to him was that all of the witnesses in the house, where they spoke to Warrant Officer Steenkamp of the Facial Identity Kit Section, the Facial Identification Unit of the SAPS, they never described how the second suspect that entered the Khumalo household looked like. Now, if the exercise of the photos, according to the state, is to then canvass this issue, my lord, we are going to make the following submissions at paragraph 2.1 of our heads of argument to say the 16 or so photographs that the state seeks to introduced are not new evidence. These photos, at the time Warrant Officer Ndlovu testified initially in this case, we were told that download analysis were done on the SIM cards and the SD card belonging to accused or Mr. Ntanzi in respect of those devices being found in his Samsung cell phone. Now we are saying, my lord, at 2.1 that the state had ample time at the time to lead Warrant Officer Ndlovu on the totality of all the photos that were germane in their examination of Warrant Officer Ndlovu at the time, not as an afterthought. If the state, my lord, we submit, were using a stratagem that we are leading this, we are leaving this out as a strategy, not as an omission, not as an oversight, not inadvertently, then we are saying, my lord, they must lie on the bed that they made. They adopted a particular strategy. Now they come later and quote Hepworth. Hepworth does not assist the state, my lord. Hepworth says an omission by another party should not be taken advantage of by another party, my lord, in proceedings. And Hepworth also deals with the duties of the presiding officer, who we are told is not an umpire. He directs proceedings to make sure that justice is not only done, but justice is seen to be done. So we are stating, my lord, still at paragraph 2.1 of our heads of argument, that nowhere does the state state that there was an oversight on their part, there was an omission on their part, and as Advocate Munisi correctly stated in his submission, at paragraph 2.3 of the state's own heads of arguments, they say, and this is the reason why, and I quote, "The reason why the evidence was not presented during evidence in chief is that it was only during the long adjournment that was afforded to Advocate Munisi to prepare his cross-examination that the state was able to go through the over 5,487 photos of the downloads. These downloads were given to the defense a while ago already. The state has extracted 3 additional photos from the downloads, including a single photo of accused number 1 that we want to show the court. Accused number 2 and 3 do not dispute that the cell phones and the SD card from which the downloads were made belong to them. The photos belong to them, including the single photo of accused number 1, and therefore fall within their knowledge. We therefore submit that they will not be prejudiced." I'll come again to this point, my lord, when I argue a different aspect, but I want to go to my second point on my heads of argument, my lord, to say that, my lord, in our view, this is cumulative evidence, which is unnecessary and prejudicial to Mr. Ntanzi. We further argue, my lord, that the state seeks to have a second bite at the cherry when they had ample time to do so during the initial testimony of Mr. Ndlovu. And this is meant just to put, as the state puts at paragraph 2.2 of their heads of argument, to say these additional photos are to show further appearances of accused number 2. It's got nothing to do with the re-examination of Brigadier Gininda on the aspects we engaged on regarding the identity kit compiled by Warrant Officer Steenkamp. And my lord, we quote the case of S. Green, 1962, 3SA 886T at 889, where the Judge of Appeal, Ogilvie Thompson, stated that an application of this nature, that is recalling of witnesses, may also be refused, and to quote, to exclude irrelevancies and discourage repetition, and I close. And my submission, my Lord, is that the photos that we've been supplied with of Mr. Ntanzi, it's a repetition of how he looks like. And the burning question is how he looks like in 2014. We don't know how he looks like in 2014. We don't know the date of those pictures pertaining to the date of the incident that this court is concerned with, my Lord. And we further quote, my Lord, the case of R versus Ghani, a 1958 case, 1 SA 102 AD, where the court held that, and I quote, a trial court must be accorded all powers to control the length to which the parties must go into investigating matter of a subordinate nature on the fringe of the case. It is important that a trial should not be unduly prolonged exposure by an over-elaborate examination of minute details which cannot materially affect the central issue. The central issue, my Lord, here is identification, and identification by who? Not by Brigadier Gininda, but by the witnesses that were inside the house at the time the offense was committed. And that description and identified as given by the very same witnesses 3 days later or 2 days later on the 28th of October 2014, after the commission of the offense, to a person, an expert in the SAPS who deals with identification, facial identification, being Warrant Officer Steenkamp. Now, at 2.3 that I've referred to as an anecdote, the state states, we therefore submit that there will be no prejudice to the accused persons by submitting this evidence. And it ends there. My Lord, prejudice is one of the factors that the state should have gone into some length, because this matter, my Lord, has dragged on. And the prejudice to the accused persons, all parties involved, the families of the deceased, they need to see this case coming to an end. And recalling this witness simply to give additional photos that add no value to the issue germane to the identification of accused or Mr. Ntanzi in particular, serve no purpose, my Lord, and prejudices the accused persons, all of them, the 5 gentlemen before this court, extensively, my Lord. Furthermore, my Lord, at paragraph 2.4 of our heads, the state sought to base their heads of argument on section 167 of the Criminal Procedure Act. I respectfully submit, my Lord, that reliance on section 167 of the Criminal Procedure Act is misplaced. Section 167 is the purview of the presiding officer, not the state, not the defense. The defense and the state can apply for recalling of witnesses that have testified that are present in court, but using a different mechanism, not 167, my Lord. And I'm not going to read 167 for the court. All of us who are here are well aware of the provisions of section 167, my Lord. At paragraph 2.5, my Lord, we submit respectfully that the issues relating to the identification and the description, especially because of what the state says I put to Colonel Gininda regarding what the witnesses said to Warrant Officer Steenkamp, I submit the following, my Lord, that These are issues that are matters of credibility that the court is seized with at the end of the case to determine on the credibility as to the description of the witnesses in the house, the description as proffered in their evidence in chief in cross-examination here in court. Re-examining Brigadier Gininda on those issues is not going to change what those witnesses told Warrant Officer Steenkamp. The other issue, my lord, that we addressed in our heads of argument is the reasons why that evidence was not led in chief. And I submit humbly, my lord, that I've already traversed this, and Advocate Munisi as well has traversed this. There's case law anecdotal at the end of the state's heads of argument which deal with the interest of justice, and we cannot fault those cases. Multi-choice, all of those cases, my lord, we are well aware of those. But the interests of justice, my lord, are a two-way street. So we implore this court to prioritize fairness, efficiency, and the interest of justice, my lord, in deciding the very fact that we are debating here in court today, my lord. And lastly, my lord, at the end of our heads of argument, we reiterate the same position, that is the right to re-examine by either the state or the defense or by the court, my lord, for that matter. And that are the provisions of section 166(1) of the CPA, my lord. I'm not going to regurgitate those, my lord. We during our debates previously, my lord, we had traversed those issues. As the court pleases, my lord, that will be my submission, that the court denied application to recall these witnesses, my lord, and to lead further evidence of Mr. Ndlovu in particular regarding Mr. Ntanzi. As the court pleases, my lord.